She's got all the info. Just call her. There's a form. Okay, if we're all ready, this is cause number 20 PR 10607, matter of the estate of Roland Lytle. Let me have everyone announce who's here. All right, I'll just go around the room here and get people to identify. As I call your name, just have to unmute. First, I have somebody who's listed as Courtney Lytle. You just state your name.
Courtney Janae Lytle.
You're unmuted, but I still can't hear you.
My name is Courtney Janae Lytle.
Yeah, it shows you're unmuted, and I can see your mouth moving, but we're not hearing anything.
Your Honor, can you hear me, Your Honor?
Just making sure she got the.
Judge.
I think it'll work.
I'm going to set this up. I was over there setting mine up. I apologize. Oh, no, it shouldn't be. Let's see if they'll do it now.
All right, so Courtney Lytle, try again.
Courtney Janae Lytle.
There we go. Now we can hear you. If you just want to leave that here also. Whoop, I tell you what, just hold on just a second. Let me sign. If I can sign that, and you can. Yeah. Perfect. So I'll just give you this file. If you can take it down to the clerk's office, then I can make you a copy.
If I just take a picture of it, I don't need it.
That's so you don't need a file stamped one.
Oh, I could take a picture of the file.
Okay, and if you just take this down to the clerk's office on the first floor. If you go down on the elevator, you go left past the switchboard and just go in and ask for Patty, and she'll be the one to file stamp that and give you a copy or let you take a picture. Thank you. Okay, so we'll resume. So
I can make it really easy for you.
Okay.
Keith Morris and Caroline Watson for our client, Courtney Lytle. Also, we have witnesses present, Stephanie Salazar, Richard Harrison, and Wanda and Gus Johnson, who are prepared to testify in this evidentiary hearing. And then we also may have another witness, but I don't think that she has shown up yet. And her name is Catherine Crawford. So these are all my witnesses, my co-counsel, and my client.
All right, perfect. So then, Mr. Bose.
Yes, Your Honor. Can you hear me? Can you hear me,
I
Your
can
Honor?
hear you fine. Yes, sir.
Okay.
So if you just identify yourself and maybe give me your witnesses.
Judge, Your Honor, my name is Lawrence Bose. I represent Karina Butler, who is a petitioner. Wasn't aware we have an evidentiary hearing with regard to this morning because the motion for the lift to objection to the standing of my client to bring it does not indicate that it covers the declaratory judgment that I filed on behalf of my client to prove up an informal marriage. And I filed something indicating that the judge would take judicial admission of the fact that the motion to object to whether or not my client has the standing to bring declaratory judgment is not a part of what was filed by the counsel for the independent executive. So we have no witnesses this morning, Judge, and I want to make it for the record that if you read it, and I want the court to take judicial notice of the fact that what has been filed does not indicate directly or indirectly anything having to do with the declaratory judgment action that has been filed. So I'd ask the court to take judicial admission of that and not entertain any such motion.
All right, well, let me look through the file. Where is the?
Your Honor,
actual-
if I may respond briefly, a motion in limine relates to whether or not Ms. Butler has standing to participate in this proceeding at all, and we've made that clear in our both responses that we filed. If I file a motion in limine saying that she doesn't have the ability to participate in this hearing or participate in this estate at all, then that covers everything, and we made that clear in our responses. Not to mention the fact that a motion in limine is in fact an evidentiary hearing. Mr. Bose has the burden of proof to show that his client has standing to proceed. In order to prove standing, he has to prove that she's the common law spouse. And so we have witnesses to provide controverting testimony to any testimony that he or she may offer. So this was made clear. I don't think that he may have misread the pleadings, but the motion in limine covers the entirety of her ability to participate in this probate matter at all.
Judge, may I speak, Your Honor?
Yes, and then I'm looking in the file to see, was there a setting or a letter or an email or something that said what we're going to hear today?
Yes, Your Honor. Your
Coordinator?
Yes, your coordinator, Ms. Guerrero, sent an email out and said that we were going to hear this matter today, the motion in limine and the motion to dismiss. If we get to the motion in limine, then obviously the court will just dismiss it. And if the court finds that she doesn't have standing to proceed.
Judge, may I speak now at this time, Your Honor?
Yes.
Judge, first of all, that we're supposed to be having, I asked for a temporary injunction. And I think what I got was indicating was a temporary injunction hearing at a status quo. And again, I take strong objection to what counsel for the independent executor is saying. My client does not have standing to prove she has standing to prove that she was the common law wife of the decedent Roland Lytle. And that, Judge, is both frivolous and groundless with regard to that, Judge. We brought the declaratory judgment pursuant to 2.401 of the Texas Family Code. And that shows what proof we had to prove up an informal marriage. What we intend to do, Judge, this is not a summary judgment motion. We have not had any evidence of that. We have a right. In fact, the counsel for the independent executor has not even filed an answer to the declaratory judgment. He's filed a response, but he has not even filed an answer. We were, in fact, going to file a motion for default. We held back on it. Only recently has he sent to me what he considers to be his initial disclosures within the last couple of days, Judge. But today is not an evidentiary hearing with regard to the declaratory judgment. And there's nothing, he cites no case law, which indicates that you can have this kind of hearing with regard to someone who has filed a declaratory judgment to prove of an informal marriage. And so, Judge, I'd ask him to do that. And I think he's getting these things confused, and he's making something very, very simple. That is, Judge, first of all, I filed a will contest, okay, on behalf of Karina Butler, indicating she was a surviving spouse. They objected to it on the basis that she had no standing and she was not an interested party. Well, we took that for granted, Judge, because what we did in fact do then was file a declaratory judgment to prove what she was in fact the common law married wife of the decedent. We in fact, Judge, decided then we non-suited the will contest with our ability to refile at the proper time, because, Judge, it is our contention that the copy of the alleged will of the decedent should have never been admitted to probate. That he did not, the counsel for the independent executor did not comply with any of the statutory requirements for proving up a copy of a will to be admitted into probate. So the only thing we have today, Judge, that I'm aware of is with regard to the fact that temporary injunction hearing that I've asked for, as well as a status quo. But as far as the declaratory judgment, Judge, there's frivolous and groundless to try to give an evidentiary hearing at this time, because he hasn't even answered to the declaratory judgment, and you will not find an answer in the file to the declaratory judgment. Now, I also, when I served the citation of petition, I also at that one time I had the mother of the independent executor in. When I filed that she in fact filed an answer, the record will show that she in fact filed an answer. And then in fact, Judge, we actually did some discovery. I did initial disclosures. They gave me initial disclosures. I sent them discovery. They answered our discovery. They sent me discovery. I have since that time non-suited the mother of the independent executor from the case. But as far as an answer from the independent executive, no answer is on file, Judge. This is totally inappropriate with regard to trying to have an evidentiary hearing with regard to something that he doesn't even indicate in the motion whether or not she has a right to standing. And it is totally ridiculous to try to say that you got to have standing, Judge. A person has to have standing in order to prove standing. With regard to the thing we've proven, Judge, is the fact that she had a formal marriage, an informal marriage with the decedent prior to his death on May 30th, 2020. And that's what we're here for today, Judge. That's all.
Your Honor, there is an email.
Just wait. I want to, since the emails are not in the file, I'm going to have Maria bring in the emails to see what.
I can point the court to the email on Tuesday, March 8th at 4:59 p.m. says, counsel, in light of the developing situation with acute confusion of the intent behind the motion for non-suit, will be setting a half-day hearing to hear Mr. Morris's motion to dismiss and motion in limine. Once Judge Leedy rules on that portion of the hearing, he'll go into other motions that need to be heard on behalf of Mr. Bose. So,
okay.
So hold on, Mr. Bose, please don't interrupt me. So we have filed an answer to his declaratory judgment. He has filed documents in a probate proceeding in this estate. If his client is not the common law spouse, then she does not have standing to file those things. As a result of that, we filed a motion in limine, which covers everything. And it's very clear in our documents that we filed where we've cited case law. Mr. Bose has filed a bunch of pleadings, the same stuff he said every time in there with very little evidence, very little anything other than citing the statute on a common law marriage. We provided the case law on what a motion in limine means, which it means if his client doesn't have standing, she can't do anything in this case. She doesn't have the opportunity, the ability to come in and object to anything or file a declaratory judgment or anything in that nature at all. And so since we were told this was a half-day hearing in order to hear our motion in limine, our motion to dismiss, we have witnesses for the court. If Mr. Bose did not do his job and get his people ready to come testify, that's not my problem. But this petition for his client to be declared common law spouse is what's frivolous. And I think that the witnesses that we have made available to testify today will show the court that. And so I'd like the opportunity to prove that up, hopefully get the court to agree with me on the motion in limine, and we can put this all behind us. Because in addition to all the other things he's filed, his client is living in the estate house, has filed a lis pendens against the house, which needs to be removed, and has zero evidence that she's the common law spouse. And so we'd like to go ahead and have our hearing, our evidentiary hearing. A motion in limine is an evidentiary hearing. He's required to provide evidence that she has standing. I'm allowed to provide controverting evidence. And so I'm ready to go. We've known about this since March 8th of 2022. I've prepared everything. I've filed appropriate responses. We have answered the deck action. We have answered the temporary injunction. And so we're ready to go.
May I speak now, Your Honor?
Well, and I tell you what, you can, but I'm going to go ahead and have Maria bring in that email on March 8th.
Okay, Judge, Judge, may I speak at this time, Judge?
Okay, and then Mr. Bose, the court reporter, just asked if you can slow down a little bit since she's taken down everything.
All right, may I speak? Thank you, Your Honor. I told Judge, despite what the counsel has said, indicated, I have in fact submitted evidence with regard to the fact that my client is the common law wife of the decedent. It is attached as exhibits to the petition itself, Judge, that was filed for declaratory. I have a list of over 40 people, Judge, who were willing to testify with regard to this, Judge, and the proof of it's our proof to prove it up, Judge. This is not a trial. He is trying to, if the court would take judicial notice of the fact that even if that email indicates that it was supposed to be here for standing, whether or not you can bring standing, Judge, what he has filed says absolutely nothing about the declaratory judgment. Again, Judge, my client does not have to have standing, first of all, to prove up standing. We also have, in addition to that, Judge, put other evidence with regard to it. It's an affidavit and clear for all the three requirements for proving of a common law marriage. And that is uncontroverted, Judge. First of all, any witnesses he have cannot controvert the fact that my client and the decedent agreed to be married. There's absolutely nothing that you can do. The case Russell versus Russell, 865 Southwest 2nd, indicates clearly that an informal marriage does not have to be proved up by direct evidence, can be proved up by circumstantial evidence. And I have all the exhibits, and we here at this time, Judge, would submit all of the exhibits that I have attached to the petition, Judge, as in fact the evidence of a common law marriage. When he says that there is no evidence that I have submitted to this court, that is not the truth. He is trying to confuse things, Judge. If you look at the petition itself, declaratory judgment, not only I have that, Judge, one of the last things that the decedent did before he died, a month before he died, Judge, is to go and buy a mattress with regard for he and my client. And he is with his credit card, Judge, and he indicates on that credit card to tell them to fill out the invoice indicating Mr. and Mrs. Ronald Light. Well, it says Corona and Ronald Light, Judge. And that's circumstantial evidence of clear evidence, Judge, that there was in fact a common law marriage between them. I have people, Judge, as I said, I have 40 people who are willing to testify. And he to say they did not, he has no one that provided any evidence at all is not true at all. I have other evidence with regard to what I did, Judge. All this is attached to the petition itself, Judge. And if you want to
none of it's admissible.
Don't interrupt me, sir. Don't interrupt me. I did not interrupt. You told me don't interrupt you. Don't interrupt me. Now, what I'm saying is that if he wants to have a summary judgment hearing, have one. Today is that he cannot, by the alleged evidentiary hearing, get my client dismissed from a declaratory judgment, Judge. The fact is that he does not even indicate by his motion for lack of standing, he does not even indicate the declaratory judgment. He only indicates the will contest. That has in fact been non-suited with the right to refile at the appropriate time. He doesn't want to face that, Judge, so he didn't do his job. He's trying to confuse this court with regard to what is in fact before the court today. The declaratory judgment, Judge, gives us the right, and she don't have to stand up. She does not have to prove standing to bring it, Judge, to prove of a common law marriage. And we're willing, in fact, Judge, to go ahead and prove it. Now, the case needs to have some discovery. Okay, with regard, he is filing initial disclosures. He indicates certain people that he indicates that he doesn't even indicate what they have with regard to the case itself, how they involved with the case. It doesn't indicate they can testify that my client and decedent were not married, did not have a common law marriage. The people he does today, Stephanie Salazar, is not even on the initial disclosures. So the fact is, Judge, they're bringing up people who have never disclosed before with regard to even in the initial disclosures, trying to prove up today to try to, like it's a summary judgment motion with regard to my client, and it's not frivolous. What he's saying is totally frivolous and groundless with regard to us going forward without a declaratory judgment. Now, the only thing I'm saying, Judge, is you cannot dismiss this case without us at least having some discovery and having some things like this. And we're not even here today before that, Judge. I'm here before the court today to get a temporary injunction so they will not, he has admitted, Judge, that they're trying to throw my client out of the house. We indicate that the will should have never been admitted to probate. The counsel for the independent executor did not do his job. It was the poorest job that I've ever seen anybody trying to get a copy of a will put in with regard to it. And he violates many of the statutory requirements for proving up a copy of a will to get it admitted to probate. And what we're saying is, Judge, we are going to prove, and we can prove, that she was a surviving spouse. When she proved that she is a surviving spouse, she there, in fact, is then as an interested person who can bring forward and refile the will contest, Judge, and get that will contest thrown out, and that he'll die, and he would have died intestate. We also indicate, Judge, with regard to this temporary injunction, that we do it pursuant to 37.005, which indicates that we can do it because it's a statute that allows for an injunction against an independent executor with regard to having stop her from trying to sell the house or throw my client out of the house, Judge. And that's the reason why we have that. So, Judge, that's our position right at this time.
Okay, so first of all, Maria came in, and do you have that email? They said it was March 8th, setting the hearing today.
4:59 p.m., Your Honor.
I'm sorry?
It was the email that Ms. Salazar sent us was 4:59 p.m.
All right, so this says, in light of the developing situation, the confusion of the intent behind the motion of non-suit, we'll set a half-day hearing on Mr. Morris's motion to dismiss and motion in limine.
Okay. May I speak, Your Honor?
Okay, go ahead.
You will see, Judge, in the files that are also dismissed, non-suited the will contest, I think on March the 9th. Okay, which regard to, so everything, the only thing he specifically indicates in the motion to dismiss is whether or not my client had standing to bring the will contest. He does not mention the declaratory judgment, not at all, Judge. And for him to say that included anything else is absolutely ridiculous. To try to
We
say
filed-
that, let me finish. Do not interrupt me, Mr. Morris.
Yes, you just keep talking now.
Are you through, Mr. Morris? As I continue, Judge, he cannot in one sweep try to indicate that that also included the declaratory judgment, Your Honor. It is not indicated directly or indirectly a part of his motion to dismiss. The thing he was saying is exactly what he said in that motion to dismiss. If you read it, Judge, he's talking about the will contest and that she did not have standing. He didn't say anything about the fact whether or not about the declaratory judgment that we've proven up that she was in fact his common law wife. It has absolutely nothing to do with that, Judge. And in fact, again, as I say, Judge, it's absolutely ridiculous for him to say she does not have standing to prove she has standing by showing she's a surviving spouse. There was in fact a informal marriage. I've spoken to several lawyers about this, and every one of them told me that what Mr. Morris is talking about is absolutely ridiculous.
I don't care what other lawyers said. I filed a reply to his response and clarified, if he didn't read it, that's not my problem, but clarified the fact that his client cannot be involved in this proceeding if she doesn't have standing. It's a motion in limine. A motion in limine covers everything. We've made that clear. Mr. Bose clearly did not read the documents, although they were a couple pages. We filed an answer. Ms. Salazar was listed on the initial disclosure. She's number 15 on the witnesses on that. We've done everything we need to do. And I'm tired of the delay that's been caused by this, crazy motion. I asked Mr. Bose when he filed his non-suit if it covered everything, and he said yes. He just didn't copy the court. And so now we're here today to hear the motion in limine and the motion to dismiss so that we can hopefully get his client, who's an intruder in this proceeding, out and allow us to continue to administer this estate to its finality. And that's what we're here for today.
Judge, what he's indicated when I said yes, I do, I was talking about when I did, Judge. I don't have to tell him everything. Hello? Hello?
Hello, everyone. I just called Judge Leedy's office. They said they're having some technical difficulties, I'm sure you imagine. So they're trying to get back up. Thanks.
Okay.